Welcome to this session. In today's session, we'll be talking about Indigenous knowledge and IPRs. Before I move on to the main session, which will be focusing on Indigenous knowledge, let me give you a view about what are IPRs. Any creation which is the result of an intellect is known as an intellectual property. When I look around this room, whatever thing I see, this pointer, the mobile phone which we use, the designs of a tablecloth, all are a form of creation of intellectual property. So any creation which is the result of an intellect is known as an intellectual property. Broadly, intellectual property can be classified into two forms: industrial property and copyright and related rights. When we talk about industrial property actually means any property which is industrially applicable, which has an industrial application through which we can satisfy to the masses. The things which include industrial property are patents, designs, trademarks, GIs, traditional knowledge. And the second form of IPR is copyrights and related rights. Now, what ideas or what expressions can get a protection of copyright I'll be just explaining about those. As we see millions of ideas, they flash in our mind every minute. Some ideas they find in the shape of novels, paintings, sculptures, stories, films, music. These may be covered under the copyright protection once they are expressed. Similarly, those ideas which find practical applications and are converted into what we call as inventions or innovative designs, they can seek protection under the Indian Patent Act and Designs Act. As we know, the trade, it requires identification of source of goods and services, some imaginative words, figures, marks, they all find expressions in trademarks. And such figures and marks or phrases, they seek protection under the Trademark Act. GIs, which are also a form of IPR, they are instruments to protect a product's reputation, an associated expression and an embedded knowledge. Now, what are indigenous knowledge? The indigenous and local communities all over the world, they have over the centuries created a great deal of knowledge, and there are various ways in which they express it to the world. Access to, use and handing down of these have been regulated mainly by the local values, customs, traditions and laws. These are known as traditional cultural expressions or indigenous knowledge, or we can say traditional knowledge. So indigenous knowledge may include the knowledge of agriculture, scientific knowledge, technical knowledge, ecological knowledge or medicinal knowledge. They also include the expressions of folklore in the form of music, dance, song, handicraft, design, folk tales, any type of artwork, food techniques, dances and rituals, any type of healing knowledge, also traditional based innovations. Talking about the characteristics of indigenous or traditional knowledge, how do we say that they are indigenous or traditional knowledge, or how can they come under the purview of indigenous or traditional knowledge? So they must have some sort of characteristics. What are those characteristics? They consist in innovations, creations and practices originated and used by indigenous and local communities. They should be intergenerational, transmitted from generation to generation, and also in an oral form. So they should be transmitted in an oral form, not in any documented manner, but in an oral form. They should be usually held by the community in general, and they should not be static and constantly being evolved. They should not be static but be constantly being evolved, improved and adapted to the changing needs of the users. So the criteria for eligibility for protection of traditional knowledge or indigenous knowledge may include a unique product and distinctively associated with indigenous people or local communities. It should be a collectively generated, preserved and transmitted from generation to generation. It should also be an integral to the cultural identity of indigenous people or local community that is recognized as the owner through a form of custodian or collective and cultural ownership responsibility. What is the importance of indigenous knowledge? Why we are running towards indigenous knowledge, or we want the indigenous knowledge? The importance of indigenous knowledge, if we talk about, is because there is a lot of demand for medicinal plant. There's a rising appreciation of natural products in the cosmetic market. And why it is? Because these type of products, the natural products, they do not have any side effects, and so they are in great demand. They are also non-toxic, and they are easily available and affordable, so they are in great demand. But nowadays there's a lot of threats to the indigenous knowledge. What is the reason or why there is a threat to indigenous knowledge? Because the knowledge belonging to indigenous people are often used by others for profit, without permission from and with no compensation or recognition to these people. Which people? These people, the indigenous people. We see that the developed countries exploit these resources in the name of patents and the inventions derived from these genetic resources. This leads to biopiracy. So what is biopiracy? Biopiracy is the theft of genetic materials, especially plants and other biological materials, by the patent processes. That is why we say there is a lot of threat to indigenous knowledge. A very good example of which we can say is the use of indigenous knowledge of medicinal plants, patenting by the medical companies without also recognizing the fact that knowledge is not new or invented by the patentee. It is already available there. It was always there. So this may result in depriving the indigenous community to the rights to commercial exploitation of the technology that they have developed. Now, it is very important that we should protect this traditional knowledge or the indigenous knowledge. And what are the tools for protection? We will be discussing about the tools for protection of indigenous knowledge. There are two approaches which are looked into by the proponents of the TK protection. The first is the positive protection and the second is the defensive protection. When we talk about positive protection requires legal recognition of rights over the traditional knowledge, either under the existing IPR regime or the sui generis regime. And when we talk about defensive protection is aimed at safeguarding against illegitimate IPRs, particularly patents being taken by other over TK subject matter. So systems for protecting traditional knowledge include the customary law, the IPRs such as patents, plant variety rights, copyrights, etc. We will be talking about the positive protection and also the defensive protection. Now let's see the Indian efforts towards traditional knowledge protection. There are the three legislation or three laws which are related with protection, and they are the Patents Amendment Act 2005, the Protection of Plant Varieties and Farmers' Rights Act 2001 and the Biological Diversity Act 2002. These three legislations which we are talking about have strong linkages between them and they are often overlapping also. Talking about the Indian Patent Act, the Patents Amendment Act of 2005 has made the biotechnological process as a patentable. The amended act had changed the earlier position of 1970 Act, wherein under section 5 of the act only methods or process of manufacture were patentable. In the amended act, what we see that this provision has been dropped and now biological processes are patentable, including biochemical, biotechnological and microbiological processes. Now plants and animals in whole or any part thereof not patentable, also including seeds, varieties and species, and essentially biological processes for the propagation of plants and animals. But microorganisms are made patentable. So an invention which in effect is traditional knowledge or which is an aggregation or duplication of known properties of traditionally known components is still not patentable, and the traditional Indian forms of medicine are thus out of its purview. So we can say the Patent Amendment Act 2005 has taken care for the protection of traditional knowledge. Again, the Protection of Plant Varieties and Farmers' Rights Act, that is the PPVFR Act 2001. This act, though it is not directly related to protection of traditional knowledge, has important provisions of benefit sharing and farmers' rights. The plant varieties which are not patentable under the Patents Amendment Act are specifically dealt with under the PPVFR Act, and the main focus of the Act is on defining plant breeders' rights. The Act is also extended to all categories of plants excluding microorganisms which are not patentable. So the Act creates a regulating body, the Protection of Plant Varieties and Farmers' Rights Protection Authority, which is empowered to determine the applicable benefit sharing. By benefit sharing is meant to provide individuals or groups with the possibility of receiving financial compensation when a protected variety is developed. Again, we have the third act or the third legislation, which is the Biological Diversity Act. The Biological Diversity Act 2002, it gives effect to the mandate of CBD, the Convention of Biodiversity, and to some extent to the Treaty on Plant Genetic Resources for Food and Agriculture. It addresses the issue which are relevant to biodiversity management in general and PGR's management in specific. So the Act is more explicit in its approach towards the traditional knowledge, and it contains elaborate provisions on benefit sharing, but it is weak in relation to prior informed consent and the involvement of communities in decision making. So the main focus of the Act, if we see, is to regulate access to GRs, genetic resources, and associated traditional knowledge by foreign individuals, institutions, or companies with the purpose of securing equitable sharing of benefits arising out of the use of the resources with the local people who are conservers of biological resources and holders of knowledge and information relating to the use of these resources, and also to protect knowledge of local communities related to biodiversity. When we talk about the defensive mechanisms, we have the Traditional Knowledge Digital Library, the TKDL, which is also known as the TKDL. TKDL is a tool for the prevention of misappropriation of traditional knowledge. It records our age-old traditional knowledge. It contains more than 2.60 lakh formulations from the texts of traditional medicine systems of India, which are Ayurveda, Unani and Siddha. And this library gives access to non-patent literature databases on traditional knowledge of India. So we see the TKDL is a documentation form of the traditional knowledge. Further, it acts as a bridge between the formulations which are existing in local languages and patent examiners at a global level. It is also, you can say, as a fusion of countries' traditional knowledge with the modern science, and the information which is available in 5 international languages, which include English, German, Spanish, French and Japanese. Now, it will also be mandatory for the patent examiners to refer to this database before granting a patent now. So, this is how the TKDL protects though it is in a documented form, it is protecting the traditional knowledge from being outsourced or from being used by the R&D companies. Now, we will be dealing with some of the cases, how India has protected its traditional knowledge. The first case is the neem patent. We know that the US Patent Office had granted patent on a fungicidal product derived from seeds of the neem. India opposed the patent by claiming that the fungicidal properties of the neem tree had been public knowledge in India for many centuries. We see that the oil from neem has been traditionally used by the farmers to prevent fungus. It was neither a novel idea nor it was an inventive idea. So the patent finally was revoked by the European Patent Office. Again, the Haldi patent. In December 1993, a patent was filed by the University of Mississippi Medical Center, Mississippi. Applicants received US patent for the use of turmeric powder as a wound healing agent. And Indian government had objected to the patent. Now, the turmeric patent failed to satisfy the criteria of novelty in view of the cited turmeric qualities documented in ancient medical textbooks. We also see the Basmati patent, how India fought for the Basmati patent. The case is of such a kind that Rice Tech, a US company, it obtained a patent on a type of rice produced by crossing a strain of Indian Basmati rice with an American variety. Now, the patent which was claimed the rights in respect of Basmati-like rice grown anywhere in the Western Hemisphere. It also claimed the future rights on any new varieties produced by crossing the new variety with existing Asian varieties. The farmers of India, they argued that an American rice producer should not be allowed to use the name Basmati because Basmati rice is a valuable export crop which is earning India approximately $800 million a year. So, as a result of a worldwide citizen campaign against Rice Tech Basmati patents, USPTO had to struck down large sections of the Basmati patent. So, with that, I think we have come to know that indigenous knowledge or traditional knowledge or knowledge of the indigenous people is knowledge which though may not be codified, but is a very useful and important knowledge. And we need to protect. India has made a lot of effort to protect this knowledge by amending its Patent Act, by giving it a place in the PPVFR Act and also in the Biodiversity Act 2002. We also have the TKDL, the Traditional Knowledge Digital Library, which has to a larger extent tried to protect the knowledge which is existing in the indigenous people. I hope you have enjoyed this session. With that, I come to an end of the session. Thank you very much.